Duress. Duress is a cause of action and a defense. It arises where one person forces another to take some action damaging to himself in circumstances that allowed no other reasonable course. Coercion is not a proper way to get others to do things. And if one party coerces another to do something injurious to the other, then the injured party has a cause of action for duress to recover his damages. If, on the other hand, one is coerced into signing a contract, i.e. a traffic ticket on the fucking side of the road, which is otherwise identified as a security, a negotiable instrument, all right? For example, and the person coercing sues the person coerced for breach of contract, the person sued has the defense of duress, i.e. an opportunity to argue that he should not be bound by the contract since the contract was obtained by coercion, i.e. duress. So, are you losing it? Why would I be losing it? Anyway. Interesting comment. Anyway, a ticket sign on the side of the road. People ask me, oh, if you get pulled over, what do you do? Hell, I encourage them to write the ticket. You do what you think you're well within the bounds of the law to do. Know that it comes with consequences, okay? So if you bring me back a ticket and I ask you, what happens if I don't sign it, and you inform me that you are going to take me to a jail, and I ask you, is that place undesirable? Do people enjoy being there? No, not typically, Derek. Okay, so again, if I don't sign this, you're going to take me to jail. Is that correct? I just want to make sure that we're perfectly clear here. Yes, so you will take me to a place that's less than desirable from any other place. It's not enjoyable. It's not an amusement park. It's not somewhere I desire to be, right? Correct. And if you keep getting lippy, we may put you in solitary confinement. Oh, is that better than jail? No, it's worse than jail. Okay, so you're telling me right now if I don't sign because you believe that I have some obligation to sign this infraction on the side of the road, which is really a security, that I will be put in a position that is less than desirable, correct? Yes. Okay. Under that information, I will sign this under duress, and I will sign that I was coerced in doing so, okay? So I sign it under duress, writing on the ticket that coercion by an armed, vietus arms, by an armed man on the side of the road, coerced me into doing so, okay? And he threatened me with a cause of action stating that he would take me from a particular place at a particular time to another location without taking me to the magistrate, which he's bound to do by law, and instead would fingerprint me, photograph me, and stick me in a jail cell, okay? So he would become the judge, jury, and executioner on the side of the road. And in doing so, he has committed an abundance of crimes, okay? So when you understand this, now you can use it to effectually gain your remedy from it, okay? Duress. The fact issue before the court in such cases is always whether and to what extent the power of duress was in fact irresistible, which is also to say whether the party coerced had alternative choices by which he might have avoided the result. For example, if one says to the other, I won't go to the prom with you unless you sign this contract, that's not significant grounds for coercion. On the other hand, if one says to the other, while pointing a loaded .38 revolver to the other's head, sign Z paper, old man, a cause of action for duress is available, and the coerced party will prevail if he can prove that he had no alternative by which he could avoid being shot. The dividing line between these two extremes, of course, is somewhere in the middle. Where is the issue for the court to decide? Too far towards the threat of not going to the prom, and the plaintiff's case will be dismissed and at the outset or won by a summary judgment after some discovery is had. Too far to the threat of having a pistol bullet pass through the brain, and the plaintiff will most surely win if he can prove that the threat was real and no alternative was available. Elements. The elements are simple to explain but difficult of proof. 1. One side has involuntarily accepted the terms of another. 2. Circumstances permitted no reasonable alternative. And 3. Circumstances resulted from the coercive acts of the other. Note the word reasonable in the second element. Clearly, the old man coerced at gunpoint could disarm the one threatening him by unscrewing a table leg and beating the other to death. However, the court will not require such an unreasonable alternative. Coercion must be real, material, go to the heart of the issue, and reasonably unavoidable. Defense. Legal right. It is not coercion to threaten to do what one has a legal right to do. For example, if one of two neighboring farmers enraged in a feud threatens to raise pigs if the other does not stop planting tomatoes, the tomato farmer might complain to the court that the pigs are a very smelly and sometimes noisy animal, and that he's being forced to raise tomatoes under duress. In fact, if the pig farmer has a legal right to raise pigs, the tomato farmer has no cause of action whatever, and his cause should be dismissed for failure to state a claim for which relief can be granted. Reasonable alternative. If a party claiming he was coerced into signing a contract during a long-distance telephone call from another 500 miles away, threatening to punch him in his nose, a court might rule that the threatened party had reasonable alternatives, that the threat was not imminent, that the threatened party could notify the police, the threatened party could avoid the other party, or take any of several alternative courses to avoid being punched in the nose, each of which would constitute a reasonable alternative that defeats the cause of action. Free choice. If the party allegedly threatening the other can show that the other actually acted out of his own will, ergo, that the act did not result from any threat, then the party alleging that to have acted under duress loses his cause of action. The cause of action only arises where the act is in response to the alleged coercion was involuntary. Comments. Duress is similar to undue influence, another cause of action arising where free will of an individual has been overcome by influence of another. See undue influence below for details on this related cause of action. The next topic we're going to cover is fraud. Now, everybody says fraud vitiates everything. There is an exception to fraud vitiating everything. If you participated in the fraud does not vitiate everything, okay? Now, if there was fraud by way of inducement, you in good faith entered into an agreement, you weren't made keenly aware of all the circumstances, and later on you determined that some of the actions that you were involved in were fraud, you'll have grounds to vitiate everything that happened. But if you participated in the fraud, you knowingly, willingly, and intentionally participated in it, your argument may be futile in a court. Fraud. In order for fraud to give rise to the right to sue, i.e., a cause of action, defendant must do more than merely state a falsehood. It's true that making a false statement is fraud. However, it is not actionable fraud, i.e., merely lying does not by itself give rise to a right to sue. In order for a plaintiff to have a cause of action, he can sue upon it is necessary that the lie be coupled with other elements. Only then can a court give the plaintiff a remedy by way of a money judgment for damages that resulted from the fraud. Moreover, the underlying facts pled in a complaint for fraud must be very specific in setting out the elements. General statements will likely result in a motion to dismiss for failure to state a claim for which relief can be granted. The plaintiff must specify the facts that set out each of the essential elements of this cause of action. Fraud may be called misrepresentation or fraud in the inducement. The elements that must be alleged in a complaint and proven by a greater weight of the evidence are the same regardless of the name. Elements. 1. A false statement, verbal or in writing. 2. False statement the false statement concerns a material fact, i.e. a fact that goes to the heart of the plaintiff's damages. 3. Defendant knew the statement was false at the time he made the false statement. And 4. Defendant intended the plaintiff to act in reliance on the false statement. 5. Plaintiff reasonably relied on the statement and acted upon it. Some authorities say the reliance must be justified, reasonable, or justified. It is the same meaning, and the plaintiff must act in reliance on the false statement of material fact. 6. Plaintiff suffered damages by relying on the false statement. That ties us into Title 15, 1692, false and misleading statements, Title 18, subsection 1001, false conveyance of language. Let's see, what else can we tie it to? In Title 15, I believe, if my recollection serves me correctly, false and misleading and deceptive trade practices as well. Okay. 6. Plaintiff suffered damages by relying on false statements. If an inebriated patron in a local tavern suddenly exclaims, "Oh my God, there's a giant elephant sitting on your car, Phil," and Phil jumps up to go look, stumbling over the leg of his own bar stool in the process of falling flat on his face, Phil has no cause of action against the other fellow because it wasn't reasonable to rely on the statement. On the other hand, if the travel agent promises Phil a trip around the world in a luxury liner for $7,000 when in fact the agent knows the luxury liner is a rusty island freighter carrying lumber from Miami to Jamaica and returning a week later with a whole hull full of pineapples and bananas, then if Phil pays his money before discovering the false promise, he has a cause of action for fraud. All essential elements are met. He also has an action for breach of contract, both of which should be pleaded. So there's another issue here. When we talk about like Pfizer and the vaccinations and all this stuff, they say that they're immune from being sued based upon their product. But here's something that was fantastic that Mr. Anonymous pointed out was, yeah, although they may be immune from suit about their product, they're not immune from making false statements. So go back there and look at the ingredients or the side effects and all that stuff where they list all the side effects, when they list all the damages that can occur, and look in there for the false statements, because although they may be immune from being sued on their product, they're not immune from being sued for false statements. Okay, so that was kind of cool of him to point that out. I still get a kick out of this. Are you losing it? I'm not losing it. Funny that somebody would say that. Defense. The following may be defenses to cause of action for fraud, bad faith. In some jurisdictions, the courts will require further showing that the false statement was made in bad faith or with reckless disregard for consequences of relying on the statement. This is not necessarily in the majority of the courts. Class action. In some jurisdictions, courts will not allow fraud as a cause of action brought by a class of persons. The theory behind this position is that fraud is directed at individuals, not groups of individuals. In pari delicito, P-A-R-I-D-E-L-I-C-T-O, pari delicito might be French. If the would-be plaintiff in a fraud case is himself guilty of participating in the fraud, courts may refuse to award damages. The theory is that one should never receive the court's benefit from the consequence of a plaintiff's own wrongs. That's also supported by the maxim, all right? Can't benefit from your own wrong. Promise. A promise to do something in the future normally does not give rise to a cause of action for fraud. It may give rise to a breach of contract action. However, unless the false statement concerns a material matter in the past or present, a cause of action for fraud normally does not arise. If the promise was made with the intent never to perform the promise, then a cause of action for fraud may arise. However, proving intent not to perform is a steep hill to climb. Okay, it's like proving a negative. In order to prove intent, the only way you can prove intent is if the one you're bringing an action against actually states what his intent was. Intent really can't be proven, it must be declared. Another type of fraud related to contracts is fraud in the inducement, covered elsewhere. Puffing. When a salesperson claims the used car you are about to drive is a sweet running automobile with a suspension system that's like riding on a cloud, even though these may not be technically true statements, they are considered statements of the salesman's opinion of puffing. Such statements of opinion do not give rise to an action for fraud. A buyer is obligated to test the product and form his own opinion. If one buyer of a car, if one buys a car vacuum cleaner, a miracle toothbrush solely on representation of a salesman's opinion, the buyer has no cause of action for fraud. If in the buyer's own opinion these things are not true, if the car salesman, on the other hand, claims the actual mileage is only 9,827 miles, when he knew, in fact, the mileage is 109,872 miles, a cause of action certainly does arise, and the buyer can prove his claim. He may win a judgment for punitive damages over and above what he paid for the car. In some states, statutes provide criminal penalties for such motor vehicle odometer fraud. Generally, for false statements to give rise to a cause of action for fraud, the statement must be one of fact, past or present, and not opinion. Comments. Omitting a material fact may also give rise to fraud. It can be shown omission was intentional and for the purposes of misleading another. For example, in some courts, if the seller of a home omits to advise the buyer that the roof leaks profusely whenever it rains, such an omission is considered material and may give rise to a cause of action for fraud. The question for the court becomes whether and to what extent the omission was material and, of course, intentional. If the seller didn't know his roof leaks, there is no cause of action for fraud. If he knew, or in some courts, even if he should have known, the materiality of the diminution in value of the house by its leaking roof is such that the court will impose a duty on the seller to report to his buyer the hidden defect or be liable to the buyer for fraud. The degree of knowledge on the part of the person making the false statement or omitting a material statement may be measured in one of three ways, each requiring a different degree of proof. 1. The maker actually knew of its falsity. To prove this, of course, the plaintiff must show the maker had actual knowledge the statement was false, i.e. that the maker knew at the time of the statements were made that they were not true. And 2, the maker had no knowledge of its falsity. To prevail in its circumstances, the plaintiff must show the representation was made in such absolute unqualified position terms that a reasonable person would infer the maker had knowledge of its truth. Fraud arises if an office supplies salesman claims the printer holds 250 sheets of blank paper and prints in 256 colors. If the printer only holds 50 sheets and prints only in black and white, the specificity goes beyond opinion and the salesman is held liable for the falsity of such specific statements. 3. The maker should have known of its falsity. To prevail here, the plaintiff must show the maker possessed special knowledge or occupied a special position to impute a knowledge of the fact, whether he knew or not. Fraud arises if a bank presents claim his bank holds $892 million in deposited assets when, in fact, the bank has only $12 million. The special knowledge or position gives rise to a duty to know what is said about such particulars material to the bank's operation. Fraud in the inducement is a particular subcategory of fraud that includes all the elements of common fraud but applies where the plaintiff suffers damages from entering into a contract. Ergo, contract to rent, purchase, or perform services. After being persuaded to do so by the lies of another, as in common fraud or misrepresentation, the plaintiff's reliance on false statements must be reasonable and, as some courts put it, justifiable. Therefore, if one justifiably and reasonably relies on false statements of another to enter into a contract that causes injury, money damages, or other losses, he has a cause for fraud in the inducement. When we come back, we'll talk about goods sold.